political money is a little like water. If you dam it up in one place, it tends to pop out in another place. My name is Pam Karlan, and I'm the Kenneth and Harl Montgomery Professor of Public Interest Law and co-director of the Supreme Court Litigation Clinic at Stanford. My area of study is constitutional law generally, but in particular, the law of the political process, what we call the law of democracy. And I chose to study it because I had litigated it as a public interest lawyer before I came into the academy, and found when I got into law schools that no one was thinking about the issues systematically. Some of what my work is designed to do is to show how the different pieces of the system are connected. And that's important as you try to figure out what kinds of policy reforms you'd want to make, because there's a sort of law of unintended consequences in politics, that by doing something that you think will make the law better in one place, it might have that effect, but in another area of law, it may make things more difficult. We're looking this year at the 15th anniversary of Bush v. Gore, which is the ultimate in good for this day and this day only cases. A lot of this is figuring out what the law is going to look like, both in 2016 and going forward, on how to evaluate challenges to restrictive election practices. In 2016, we're going to see a series of different kinds of election law cases. We're going to see challenges to voting practices and restrictions on voting practices themselves, such as the challenges to voter ID laws, challenges to restrictive registration practices, challenges to the way early voting and absentee voting are conducted. If you were to go back, say, 10 years ago, very few states had photo ID requirements for people to be able to cast a ballot and have it counted. And now a series of states have adopted these laws. If you were to go back to around 2000, 2001, many states were liberalizing their use of early voting so that people could vote before Election Day at a time and place that was more convenient for them. And we're seeing some cutbacks in a number of states to early voting. Some of how we got there was the Supreme Court changed the playing field. It got rid of a very important provision of the Voting Rights Act. Some of it is an increase in political polarization in the country that creates incentives for the people in power to cement themselves in power by keeping voters who might vote against them away from the polls. And one of the interesting things that I'm looking at in my research is how the Supreme Court and the federal courts deal with these challenges. Because on the one hand, you want to have the rules set long in front of the elections because they shouldn't be determined by the elections themselves. The kind of law of democracy we have is foundational for all the other kinds of law that we have, because our law is made by the people we elect. And it's made in referenda, particularly in California, and initiatives. And those things are governed by law. And so the kind of politics you had in the past determines the kinds of politics you can imagine and the kinds of policies you can imagine in the future. So it's a tremendously exciting area of law.